The legality of Major League Baseball's controversial reserve clause is now in the hands of the Supreme Court. The case involves the trade of Curt Flood from St. Louis to Philadelphia. That case for Flood is being argued.
It was so difficult for the fans to understand my problems with baseball. I was telling my story to deaf ears because I was telling my story to a person who would give their firstborn child to be doing what I was doing, and he just could not understand how there could be anything possibly wrong with baseball.
For nearly 3 years, Curt Flood had been in the courts, fighting a one-man battle with Major League Baseball over the reserve clause. Despite the advice of the Players' Union, he had left the game in 1969 rather than be traded against his will.
What I told him was that I agreed with him in principle, but that the courts had treated players as property and would likely do so again, and that his attempt, while a principled one, was, I thought, doomed to failure. And I worried about his knowing the kinds of chances he was taking, that he was going to end his career in a case that probably was a loser.
The lawyers for the major leagues would not talk for the cameras, but in the courtroom they argued that the reserve clause is essential to the future of organized baseball, that without the reserve clause, all the rich teams would get all the star players. But Arthur Goldberg maintains that the reserve clause, tying a player to one team for the rest of his life, is in violation of the 13th Amendment. That's the amendment against slavery and indentured servitude.
Flood's first trial had been in federal district court in Manhattan in 1970.
I think Curt Flood on the stand was treated miserably by the federal judge. He almost taunted him. A judge who showed great respect for almost all witnesses who were white. From the bench, the judge asked Curt Flood, "This is not as easy as playing center field, is it?" You know, with a sarcastic tone in the middle of a difficult cross-examination.
No active player dared testify on his behalf. Only owner Bill Veeck and a handful of retired stars came to Flood's defense.
Jackie Robinson walked into the courtroom and there was a hush. He has such a presence that you could hear a pin drop. His hair was white and he was walking with a cane, but he still had that swagger that Jackie Robinson was so noted for. But he testified in my behalf and with a soliloquy that would send chills up and down my spine.
Chief Justice Berger.
So first this morning is number 7132, Curtis C. Flood against Kuhn and others. Mr. Goldberg.
Mr. Chief Justice, and may it please the court, the issue in this case is the legality under federal antitrust and state statutory and common law organized baseballs through the reserve system. To paraphrase Judge Waterman's opinion in the Court of Appeals, this is a scheme which binds every American professional baseball player to one team, or it's assigned for life, and which compels the team owners to boycott the player or property of another team owner, and to boycott any fellow owner, and to boycott the player himself, and blacklist him, who fails to abide by the agreement among the owners to eliminate competition in recruitment or retention of personnel. The reach of the reserve system extends beyond the continental United States and even our new states. Beyond the 24 major league clubs which are defendants in this lawsuit, to 155 minor league clubs organized in 21 minor leagues, to the Mexican League and even to Japan. An American player boycotted by organized baseball today is boycotted by Japanese employers as well. Perhaps it may be helpful to the court if I have stated the issue, now revive a few of the pertinent facts. On October 8, 1969, Curtis C. Flood, then a major professional ball player of the St. Louis Cardinals, was traded. His contract transferred and assigned to another National League Baseball club, the Philadelphia Phillies, as part of the multiplayer transaction between the two clubs. As Judge Cooper found in the district court, and I had paraphrased him at the time of the trade, he was 22 years old, a veteran of 12 years of service with the Cardinals, co-captain of the team by election of his teammates, and acknowledged to be a player of exceptional and proven ability. About that, the record is very clear. In his active service with the St. Louis Cardinals, he batted around 300, won several Golden Glove competitions, which is competition for excellent fielding, and was regarded to be a great asset for the team, and is evident by the fact that he was being paid $90,000 a year. Not a salary as we know from reading the newspapers, that the baseball owners throw away very lightly. The circumstances surrounding his assignment, or as Judge Waterman said in the Court of Appeals to use baseball sale, are rather interesting as part of the background of this litigation. Now perhaps that explains why he chose to use the courts to vindicate his rights. Although he had deep roots in St. Louis, Missouri, not only with the ball club in which he served faithfully for 12 years. He was also an artist who had an artist studio. He had 2 photographic studios and a franchise elsewhere, and he had many fields and friends and family in St. Louis. He was not consulted about the training. At the contrary, he received a form of notice and then a telephone call. The form notice was a very cryptic one. Record itself does not really display what it actually is. It is a printed form, and in that printed form there's a checkbox. Your contract is renewed. Your contract code has been transferred. You have been released from service. Perhaps, I would like to suggest, Your Honors, you might want to look at the exhibits rather than the cold record to see how this form is filled out. I should say, in all fairness to my distinguished brothers on the opposite side, he also received a telephone call. After the transaction was completed, not before presumably, he had relinquished all of his rights to any consultation of disposition of his destiny. When at the age of 15 he signed a contract with the Cincinnati Reds that without the assistance of an attorney, which was the practice in those days, until very recently, until the 1970s contract. He signed his first professional baseball contract for an average salary of $4,000, which of course worked his way up the ladder, but he was playing last. He enjoyed a very generous salary. The fact that he was an exceptional player, as Judge Cooper found in the district court, and Judge Waterman, speaking for the Court of Appeals, confirmed the finding. It was illustrated by his batting averages. After he started to play full-time in 1962, he had been there since 1958 with St. Louis Cardinals, and his batting averages were in 1962, 296, 1963, 302, 1964, 311, in 1965, 310, in 1965, 267, 1967, 335, 1968, 301, and 1969, 285. I'm not a great mathematician, Mr. Chief Justice and Associates, but this seems to me to be a batting average around 300. He was also the winner of several Golden Glove awards. These are awards given to players for excellence in fielding. He got this form notice without advance consultation, and he got the telephone call telling him that he had to uproot himself, his family, his business connections, and move to Philadelphia. On December 24th, 1969, Mr. Flood wrote to the Commissioner of Baseball, responded to Mr. Brown Coon, the Commissioner of Baseball, asserting his rights to negotiate with the team, other Philadelphia and state. And it's a rather interesting exchange. This was his letter in part, the relevant part. Dear Mr. Coon, after 12 years in the major leagues, I do not feel that I am a piece of property to be bought and sold, irrespective of my wishes. I believe that any system which produces the vital result violates my basic rights as a citizen and is inconsistent with the laws of the United States and the law of the federal states. The Commissioner of Baseball, Mr. Coon, replied, Dear Curt, this is frankly reminiscent to me of the unanimous decision of the Supreme Court. which reserves the Hamilton case because a witness was addressed by her first name, while other witnesses were addressed by their last names. Putting that aside, the letter read, "Dear Curt, while we agreed with the contention that as a human being you are not a piece of property to be bought and sold, and this is fundamental to our society and could not see its applicability of the situation. Faced with him the sale, which he deemed to be an impairment of his legal rights and denial of his request that he be made a free agent of liberty to seek employment with other teams, and without subjecting the new employer to boycott by the team owners, he had no recourse in his opinion, other than to mount this lawsuit. And this lawsuit challenges the reserve system, which permits this to be done. Mr. Flood adhered to this refusal to play for the Philadelphia during the 1970 season. Well, the Philadelphia sold its exclusive right to negotiate with Flood to the Washington Senators after the 1970 season concluded, and until the necessity compelled him to acquiesce. So we have the reserve system, not unfamiliar to the court because the court has passed upon it. I think wrongly in the two cases, and particularly Toulson. I think a very accurate description of the reserve clause and contained both in the district court opinion and in Judge Waterman's opinion for the majority of the Court of Appeals, for the whole Court of Appeals. Judge Moore filed a concurring opinion. Judge Waterman in the Court of Appeals described the reserve system as a system, and I quote him, which pursuant to a nationwide agreement, and I shall say a word about that. Clubs, baseball clubs, effectively restrict a baseball player. If he desires to play professional baseball at all, contract negotiations with the club that organize baseball, which firstly employers or reserves it, or with the club's assignee club, now in the subsequent assignee clubs to which and I am quoting the Judge Waterman, he has been sold or traded. There is a more expensive treatment of how the reserve system operates, citing the rules which govern the baseball rules in Judge Cooper's opinion in the district court. Now, while I disagree with his conclusion, I do not disagree that Judge Cooper correctly describes how the reserve system operates. Briefly, in addition to Judge Waterman's pungent and succinct description, it goes beyond that. No other club may bid for his services once he signs. He is not permitted to approach any other club. That's called the no tampering rule. A club which violates this rule is subject to boycott by other clubs. In fact, any player for another club which violates this rule is subject to discipline by the Commissioner of Baseball. And it extends beyond. Judge Waterman did not deal with clubs. The major league club that extends to the minor league club, that extends to the Mexican league, that extends even to Japan. This is uncontradicted in the record. Now Mr. Flood stayed out in 1970 and pursues this lawsuit, challenging the reserve system on several grounds. First, that it violates antitrust laws of the United States. Second, it violates the antitrust laws and common law of the several states. And third, that it violates the 13th Amendment of the Constitution of the United States, prescribing the indentured service, as well as slavery, should not be permitted. Now, as he stated out in 1970, as I had said, he was confronted with 1971. And at that time, Philadelphia, the team that owned him, and again, I quote, paraphrased as Waterman's opinion, the team that owns him sold him to Washington. He agreed to play for Washington. He was there for a few months, and we can all take judicial note. I think of what occurred, laymen, lawyers, and I believe this court, he tried. He had been laid off for a year. After trying for a few months in spring training, in the actual season, he was best. He could not easily regain his skills, which is not difficult to understand, and he left. Now, the transfer from Philadelphia to Washington was accompanied by the stipulations between ourselves and opposing counsel. That was not connected to this lawsuit. I am well aware, however, that private people cannot stipulate a case for this court, but the transfer did not mute this case on Radovich, the football case. This court held that the success of a boycott did not moot the case. Furthermore, it has experienced damages in 1970, and it suffered impairment of his career. Now I turn to the reserve clause.
He indicated in his letter, I noticed in the record in his letter, in late 1969 to Mr. Kuhn that Philadelphia had offered him a contract. What were the terms of that contract? Not all the details, but in the...
They offered him an increase to $100,000 with salary and other benefits. But this was not what was being contested. He was contested being removed without his consent, and as his letter states, he didn't want to be treated as channel property. Question of principle.
I just wanted to ask you, but you are now telling us about the lack of mootness and about his damages in 1970. He was moved off for $20,000.
It is not, by the way, new, although I have seen articles about it, which indicates that this high-paid ball player did things as you know. Why did he do it when other ball players, by the way, despite all of the stories in the press in 5 years previous, had only averaged a little over $8,000 a year? Why this high-paid ball player did this? He did it as simply said, out of principle. He no longer wanted to be treated as channel property. He made that decision on his own, and although he has been supported by the litigation of the Players Association, about which I shall later have reference, this was his decision. The record is very plain on that. In fact, he was told by director Mr. Miller that he had a tough case. Nevertheless, he felt a good conscience that he had presumed.
As a practical matter, he had no real chance remaining in St. Louis and negotiating another controversy with St. Louis. He would have had to go to one on the other teams if he had been to the reserve.
Exactly. Mr. Justice provides this clause is legal, and I shall say it is not.
Even if it's not legal, if St. Louis is trading him, regardless of the reserve clause, they are not going to negotiate another contract.
He said that what he wanted. What is the opportunity as a free agent to negotiate his own deal? Not to be traded as this form that I have referenced indicates without his consent. Now, the reserve clause has been in existence 100 years long, and today any union that a ball player formed, which I shall talk about in the labor exemption, which one important modification. In 1965, the reserve system was extended for the first time to potential new players who had never signed an agreement with any team, and typically these are teenagers just graduated from high school or have dropped out of high school. This had never been done. This category, not in the minor leagues, they until 65 enjoyed the privilege of negotiating their first contract. That no longer exists. They have a semi-annual draft. There's another factor which I shall refer to when I talk about the so-called labor exemption. Judge Cooper found that the baseball reserve system is not presently collectively agreed to. Citation is in my brief. I shall not burden you with this citation. Now, when the Flood decided to sue, he challenged, as I have said, on several grounds.
Mr. Justice, may I ask you, suppose it had been collectively agreed to, would your position be any different?
No. And I shall discuss that when I come to the labor exemption.
I hope you are going to get to that.
I will move fast. Because of the shortness of time, we have these three of our positions. On the first antitrust laws, we are confronted obviously with two decisions in this court. Federal baseball decision in 1942 and Toulson decision in 1953.
And as they would have to be overruled.
They would have to overrule. They should be overruled. They should be overruled for very good reasons. They should be overruled because the first one of federal baseball was not, as Judge Friendly said, Justice Holmes' happiest hour.
But I take that, Mr. Justice, those both dealt with the issue of statutory constructions.
Yes, but even then it showed. I doubt that Justice Holmes had never seen a ball game.
The court doesn't readily overrule as a statutory construction.
Yes, but it has quite recently, as I shall point out in a moment in reading the throwing opinions written by Justice Stewart for unanimous court in constructing statute. There is a case put aside in the Collins versus Hardiman. The federal baseball, in fact, was abandoned by Justice Holmes the very next term. And Toulson was a per curiam which merely said that while we have done it, even though we think it's wrong because interstate commerce has changed, well, we'd rather leave it to Congress, and the court was troubled at that time with whether or not prospective rulings could be met. The problem, of course, has been settled by this court, even quite recently, and I shall mention that. Now, I say to you very simply, I shall not be elaborate that the federal baseball was wrong. The development of law, or what constitutes the commerce, was considered the base, and no one would doubt that baseball is engaged in interstate commerce. The court in Radovich, this court Schubert Theaters, this court in the boxing area have all characterized sports. If they are so called as an interstate conference, baseball indeed is an interstate conference in a very big way. That is a tremendous institution that sends people all over the company and in Canada. It realizes enormous revenues from television. I think I saw the other day in the national contract television rights, they realized $41 million, and then it supplemented their local contracts. Now we have here a question of state decisis that I thought that this had been put to rest involving statute.
Mr. Justice said just before you start on that, do you think federal baseball and Toolson indicated that the baseball was not engaged in interstate commerce, or is it that labor isn't an article of commerce? Service is not article of commerce is a matter of statutory construction, then the intent of Congress. Would you just say that labor is an article of commerce?
It depends on what way labor is treated. Labor should not be an article of commerce. Clayton X says it should not be a commodity.
Well, is flood different?
Yes, because he is treated as a commodity, as everyone is under the reserve rule. He is not treated as labor as we traditionally understand labor people to be treated. Free American workers determine their own destiny.
But in any ways, I gather Radovich settled that?
Yes, it did. The same issue was Radovich and decided against the football owners, which brought Radovich, which were involved in Radovich's decision in the court. It was argued in Radovich, and I do not know what prompted this court to take Curt. I had not assumed the purpose of the grant and then necessarily follows. If it is treated as labor exemption, which I should talk about, if it is decided that the labor exemptions so-called applies, then this certainly applies to football. They have a union. It certainly applies to hockey and the consequences of a decision. Holding that the labor exemption applies to baseball may necessarily mean that it applies to all of the sports, so-called sports. Otherwise, it's very interesting when you read this record, as I know you all have or will. Brown-Kahn, the commissioner of baseball, does not refer to it as a sport. He refers to an entertainment. As entertainment is governed by your decision in Schubert, which says the subject to antitrust regulation. The decision, Justice Stewart, that I had mentioned, in a statutory construction is your own Griffin versus Breckenridge. Perhaps I shall read only a few sentences. Whether or not Collins versus Hardiman constructs the Civil Rights Acts correctly decided in its own fact is a question with which we need not be here concerned. But it is clear in light of the evolution of the decisional law that had passed since the case, which was decided on many of the constitutional problems there. Proceeds simply do not exist. Justice Holmes conceived that there was a constitutional problem. The only reason remains, therefore, not to accord with the words of the statute, their apparent meaning. I move quickly to the next point. I think that it ought to be overruled. It is anomaly in the law. Every commentator has said it is an anomaly in the law to adhere to the Toolson and federal baseball as improperly decided. Now I move quickly to the next point. And that in state law, peculiarly enough, as Judge Waterman even says, we were in the horns of a dilemma. The federal law did not apply. It was not interstate commerce. Why should not state law apply? Judge Waterman said, contrary to the district court, which said as preempted, Judge Waterman says, that it was interfering with interstate commerce. I take this as no foundation whatsoever. The decisions of the court are plenty and ample. Well, the subject that state law were carried out for the purpose of the great federal statutes for Sherman Act, which are not inconsistent, ought to be applied. And then that is the law. Authoritatively, the Sherman Act said that our own law is designed to supplement, not disgrace federal law. There is no preemption here. Expressed or implied, there is no conflict, nor is any court found one. Judge Waterman says there is a necessity for uniformity, or there was no inquiry into the state statutes to determine whether there was. We have listed the state statutes and briefly summarized. They are the same as the Sherman Act, those states that have adopted it. So the decision, for example, in the Continental Airlines cases covers.
Has the petitioner left baseball?
Pardon?
Has the petitioner left baseball?
Yes, he left. He left now.
Is the case moot?
No, it is not, because the 70 seasons, in the season where he was right to recover damages because he returned later and has also the right to decide if he wants to go to minor leagues or Japan, which are subject to the same rules. I will say one word. I shall take a few more minutes of my time and comes off of rebuttal.
Excuse me, your time is completely consumed, but we'll extend it 3 minutes and enlarge yours 3 minutes, Mr. Potter.
There is nothing too bad to the baseball argument than a newfound affection for the collective bargaining in the Labor Act. I share that the affection, in fact, I shared it for many, many years. Under the decision of the court, this is hardcore violation of the antitrust. This is a group boycotting and blacklisting, all under the rules and obligated not to deal with a player if he is on a reserve list. He is blacklisted not only here but in Mexico and Japan. And this is the most obvious restraint of the trait known to man. I'll put a simple illustration. As your honor is well known, I once represented the steelworkers. Let me put a proposition. Suppose the steelworkers union. They would never do this. Agreed with U.S. Steel that if a man signed up, he had to work for U.S. Steel all his life. And if I employed him and he left, if employed him, U.S. Steel will not supply parts of their fabricating or steel for their fabricating operations. Is there any doubt in anybody's mind that would be per se violation? Not at all. Finally, so there is nothing in this labor exemption, as the court said recently. Court said in Pennington, Justice White's opinion, you cannot just say conditions of the employment wages. You have to interpret the terms. This is perplexed to be a condition of employment. Servitude is not a condition of employment, nor a salary. Slavery. Can you conceive any union being charged with failure to bargain because of this? I cannot conceive that. Furthermore, this goes beyond the bargaining union. The opinion, Justice Brennan, that you just wrote affirming Pennington because it covers the minor leagues and it goes beyond that. So it gets out of the bargaining union. And for all these reasons, I would say that none of the arguments have any basis. Mr. Flood, the victim of a reserve clause, which in my view violates all the antitrust statute.
Mr. Potter.
Mr. Chief Justice, and may it please the court, I wish to take about 5 minutes. I represent the respondent, Valley Kuhn, Commissioner of Baseball, who was the defendant below on the court of one, and that was the antitrust law. Mr. Holmes then will discuss the issues in the case, and totally what we all agree is the central issue. Mainly that this litigation involves basically a labor dispute. Now, the Commissioner of Baseball serves for a term of 7 years for odd plenary powers both in administrative and quasi-judicial nature to preside over the institution of professional baseball. His first point, fundamental function, is to maintain the integrity of the sport on the playing field and public confidence and honesty of the game. He has the authority under the rules of baseball to take whatever action in his judgment is in the best interest of baseball. And he has acquired on frequent occasions to evaluate it in the best interest of baseball, under that standard and that way in the interest of players, and perhaps their fans alike. Now, baseball, as it has been recognized by this court again and again, is a unique structure, primarily bottomed on responsible self-government. The office of the commissioner, as we all recognize, was established to police the honesty of this court, since it is developed into institutional apparatus to reconcile many minor and major issues in appropriate administration and the structure as a whole.
Well, Mr. Porter, is the structure of other sports different to football, basketball?
Not presumably, Mr. Justice Brennan. Many have copied, including the reserve systems, essentially the same structure and the same pattern as baseball.
Yet they come with the application of the antitrust law.
Well, it has never been challenged, except in Rodovich. They have a settled number of cases, as Mr. Hoynes will develop. The Spencer Haywood case is a notable exception, and they have been living on the brink, I think. They recognize it.
You are not making an argument for uniqueness of baseball and respective instructions.
Indeed, we are.
You are.
Yes, sir, and I can develop that if time is permitted, where we have spent 25% of our revenues for player development, major league revenues. Now, the other sports have their forms as the per college, and there are many other distinctions. Now, the commissioner, because of his neutral position, has no participation in the bargaining that has gone along with respect to the reserve system. Now, he testified in the district court that this system was not a fossilized system, engraved in Habris versus Stone. It was subject to changes and modifications, and indeed it has been changed and modified. The Commissioner also gave important testimony on two particular areas that I would direct your attention to. Number one, that without some continuity of employment between clubs and players, the relative equality of competition and the honesty of the sport would be seriously impaired. I would just respectfully direct your Honor's attention to the Commissioner's testimony, which is summarized in our appendix.
Does this go to whether there would be a violation of the antitrust laws rather than to coverage?
I think that Mr. Justice White, this is a labor dispute. It's a bargainable issue. As Judge Cooper found, as I think the second court and Judge Cooper said, that all evidence have not been fully exhausted in the bargaining process. And indeed, as Mr. Hoynes will develop, this issue was on the bargaining table while in the Toolsing, while this litigation was brought by the Players Union. Also, I would direct your attention finally to the Commissioner's testimony, exhibiting, which is Exhibit A, found in page 407 of the appendix.
I beg your pardon, you just said the litigation was brought by the Players Union?
It was really financed by the Players Union, and indeed, that's conceded in this record. One final point I would like to make in spite of...
Are they really saying this is their lawsuit?
Absolutely, yes sir. And in spite of all the record that we have here about this being a per se violation, and the trial record below, with the exception of the petitioner, Mr. Flood, all the witnesses in support of Mr. Flood's case testify that some form of reserve system was essential. And I will not consume my time as it is consumed, Mr. Chief Justice.
Mr. Hoynes.
Mr. Chief Justice, and may it please the Court, I am the counsel for the National League, and I am here to represent the 24 major league clubs and the 2 major leagues. The issues presented here are...
Is your position that baseball is not commerce?
No, it's not my position that baseball is not commerce, Your Honor. I think that has been well recognized. Indeed, it is recognized by the Toolson decision. The issues are here much broader than Curt Flood's particular situation, which has been described by Mr. Justice Goldberg. This is fundamentally, in our view, institutional litigation concerning the normal operation of baseball's basic fundamental and historic rules. And the real protagonists here are suggested by Mr. Justice Brennan's questions a few moments ago. The real protagonists are the Players Union, the Major League Baseball Players Association, and the major league clubs that I represent.
Does the record show us anything about the union?
The record shows in very great detail, Your Honor, as does the opinion of Judge Cooper, devoted a good portion of his opinion to tracing the effectiveness of bargaining, the effectiveness of the union.
Its extent numbers of players, or...
Yes, all of the players in Major League Baseball really are members of the Players Association. They have an association that has been recognized by the clubs as the formal collective bargaining agent for the football players. And all of the terms and conditions of employment of a Major League Baseball player are in fact on the table on a more or less constant basis.
There are many NLRB proceedings involving the relationships between the clubs.
There has been no dispute over the propriety of their representation. However, there have been a couple of unfair labor practice charges that have been brought and processed by the NLRB. And the NLRB, of course, shared asserted jurisdiction, and that point is not debated by either side. It's part of the workings of Major League Baseball as we know it today, and have known it for some time.
Both proceedings you're referring to are the ones that are by the umpires.
No, I was referring to proceedings involved in the Major League Baseball Players Association. Some of the dispute at the beginning of this year on the question of the relationship between television revenues and bargain on the pension plan. There was a dispute as to the extent to which we were required to disclose certain information. NLRB involved itself in working that matter out. The complaint was issued and so forth. There. It's a player for minor. Your Honor, I would not be able to state to you that bargaining directly representing the minor league players was being carried on, but the Major League Baseball Players Association certainly has bargained with the interests of the minor league players in mind. Indeed, many grievances have been brought before it.
The players aren't. The minor league players at terms aren't settled by the bargain between them.
Bargaining with the minor league players directly? No, there is no direct formal representation by the minor league players. That does not mean that they are unrepresented, however. I suggest that their interests as part of the...
So then your position would not be the same if this is a point on the plaintiff?
Well, my position would be the same, Your Honor. I simply would not be able to point to the direct one-to-one relationship between a formal bargaining representative and with that particular players I can with the Mr. Flood. It was clearly represented and a member of the organization, but I would still argue, Your Honor, even if the minor league player...
Mr. Hoynes, how far is this representation of Flood Curt? For example, did the owner consult with players' associations about this movement?
I mean, as far as they signed in Flood's contract?
Yes.
No. That contract assignment took place under the rules, which themselves were the subject to bargaining.
Well, how much representation did Flood get from this outfit?
Well, no one.
As to this trade, which is the basis of this suit, now what position did the union take on that? Do you call it a union?
The union, after the transaction took place, conferred with Mr. Flood, and as I understand it, and ultimately agreed with him to finance the cost of his litigation. And as I was about to point out, it is quite transparent, I believe, from reading of the record, that the Players Association, the Players Union, has in fact controlled this litigation from beginning to end.
I understand that. The union and management, what they were interested in is non-litigate, is that right?
We certainly are interested in not litigating, Your Honor. We believe that.
What if negotiation was done between this union that protected Flood?
Well, when the lawsuit,
What if anything before the lawsuit?
no representations by the union were made to us
That's normal?
seeking any.
Is that normal in union management relationship?
Your Honor, I believe it is during the pendency of the collective bargaining agreement. These rules were part of an arrangement, and bargaining was not to take place until a subsequent period. The transfer was entirely in accord because of these arrangements.
Now the union, which says the management, you can pick up a man and throw him out the door without any recourse, that's a union?
Your Honor, I don't believe the unions ever agreed to that. I don't think that's what happened with Mr. Flood.
Well, did the union agree to the bargaining, to that paragraph which is under attack here, the reserve clause?
The reserve system is not simply a paragraph, but a number of interrelated rules.
Agreed to by the union.
I believe that's right, Your Honor. I beg your pardon with the management.
Is there anything in the record that shows that?
Well, Your Honor, there are the collective bargaining agreements in the record.
Is there anything that shows that the union, which you call a union, agreed to these provisions?
Your Honor, a collectively bargained agreement is an agreement signed obviously by the union and by management and all of the major league rules which encompassed by that agreement. I can't think of a plainer way to demonstrate it.
As far as the union?
Well, the union, Your Honor, is, I think, having participated in the bargaining on the management side for the last several years, has made remarkable gains with respect to player-club relationships.
What has it done concerning individual players' relationships?
Well, the union is...
Well, I say nothing.
No, I would not say nothing.
Then wouldn't you say, under reserve clause, that there is no room for bargaining?
No, I certainly will not say that. I would say that the reserve clause itself, the very core of the reserve clause, is a subject admitted by both sides, a mandatory subject of bargaining, and something about which bargaining was going on when interrupted by the pendency of the filing of this lawsuit. And is back to that form, Your Honor, that we believe this matter should be remitted.
You mean back to the union?
Back to the collective bargaining table, but yes, Your Honor, yes.
Well, even though the union is not protecting the individuals?
Well, the union is protecting the individual. Your Honor, this union is very well.
How the union is protecting this individual, who is the petitioner, Curtis C. Flood?
Your Honor, the union bargains obviously for future benefits, and what's at stake here is the shape of baseball, and its employee relations rely on that for the future. Mr. Flood is, I think there's no question about that. He's retired from baseball now. He's through with baseball.
Would you call it voluntary, would you?
Well, I would call it voluntarily retired at this point, Your Honor. He was playing for Washington and felt that he no longer could play satisfactorily to his standards, and he had other problems as well. He left the country. We were most eager to have the employee during the pendency of this lawsuit. He told his counsel repeatedly that we would make no argument whatsoever that the case had been mooted, and that we wanted to see Curt Flood playing and living his normal life, and litigation could go forward. If they would not hear one word from us that there was something inconsistent about him playing and litigating. We made no threats. It was suggested constantly that this be done, and in 1971, Curt Flood decided he would return to baseball. His play was of the caliber that, as a proud man, and it was not satisfactory to him. He had other financial business problems which caused him to leave both the Washington area and the United States. We regretted that very much. We would have been delighted to see Mr. Flood continue a long and prosperous career.
This isn't in the record?
None of which is in the record, Your Honor.
He's playing with Washington or any of his other business?
Well, the record was closed before he began to play for Washington, Your Honor, yes. I think that Justice Goldberg adverted to it, and I'm sure you could take notice of that fact. As I had mentioned before, it is our position that the Players Union is entirely in control of this litigation, and that it is concerned less with remedying any alleged wrongs that may have been performed on Mr. Flood than it is in trying to reorganize the employment relationships in professional baseball. In other words, the union is after a larger game here, Mr. Flood's testimony itself was isolated from the rest of the case presented on behalf of the petitioner. He testified that he would like the entire system to be torn apart and like every ball player to be free to negotiate with any club of his choice. While all of the other witnesses testified on behalf of the petitioner, they limited their testimony to certain modifications that they suggested in the reserve system, all assuming that some continuity of player control, some form of player reserve system would in fact be necessary. This testimony represented a repudiation of really Mr. Flood's position and left him a forgotten man for the remainder of the case. In fact, no evidence at all was offered on the damages which Mr. Flood's complaint indicated he had suffered to his outside business interests in St. Louis. Not a shred of it was ever offered on that matter. Thus the union, as I said, was after a larger game. It intended to subvert the collective bargaining process in baseball to obtain gains which it had not yet achieved at the bargaining table, outside of the bargaining table, and to unravel the very fabric of past collective bargaining, all of which interwoven intimately with the reserve system. In order to accomplish this purpose, the petitioner has attempted to persuade this court to move radically in two new directions. First, to change the law abruptly and totally by overruling the narrow and well-confined precedents of long standing, which now indicate that baseball is not subjected to antitrust laws. And second, to declare illegal, per se illegal, I believe according to their briefs, baseball's historical reserve system, as the trial court found, the cornerstone of the game, and to act in effect as a compulsory arbitrator in an employee-employer dispute about the terms and conditions of employment in baseball in fashioning a new system. A trial was demanded to.
I would say at this point, would you comment as to why baseball moved to extend that? Why did it move into the draft system in 1965 to the new player?
Your Honor, the adoption of the draft system is simply one more step and a number of steps that baseball had taken over a period of years to try to equalize competition on the playing field. Preceding the draft rules, there were rules about bonus issues. You may remember this. If a bonus of a certain size was awarded to a player, the player must serve immediately on a major league roster. All of these were efforts to prevent the clubs with the largest accumulations of wealth in being able to attract the most skillful young players, and none of those systems soon.
The bonus system itself didn't come into effect until fairly recently.
I beg your pardon?
When are the first bonuses paid?
Well, I think the first bonuses were probably a large amount, were paid in the 50s. Sometime before the rule or the 65 free agent draft. I might note on the free agent draft subject that all of the other sports have free agent drafts. In fact, in the other sports, the rights to negotiate with a player are perpetual. Once he is an amateur is drafted, he can negotiate only during his lifetime with the club that drafted him. And in baseball, the negotiating rights are only of 6 months duration. And if a player doesn't sign with the club that drafted him, he may be reselected by another club.
Mr. Hoynes, what are the principal differences between the standard National Football League contract and the type of contract which Mr. Flood had?
Well, Your Honor, there are a number of differences in the employment relationship between football and baseball, and a number of differences in the sport, the character of the sport themselves. An obvious difference that receives much publicity is the option rule in professional football, a system by which a player can declare at the beginning of the season that he desires to move to another pasture at the end of the season. He then plays an option. They call it the option. At the end of that additional year, he is technically free to seek employment by another club. The rule has another provision that says that any other club that signs that player must compensate to the club from which the player came, either in the amount measured by the money, players, draft choices, what have you, satisfactory to that former club, or if a new agreement can be reached, that the commissioner will establish compensation. The Major League Baseball Players Association announced this arrangement as essentially a fraudulent one, and in fact there's been a little mobility historically in football. And if one examines the collective bargaining process going on in football, one will see that the football players themselves denounce the arrangement as being essentially a cosmetic one, not one that affords them any real freedom of choice, and then seeking their employment. Other differences in the employment relationship in football and baseball. Rather than football, the management may establish the rules of the game. In baseball, our collective bargaining agreement expressly recognizes the duty of the Major League clubs for enacting any rule or involving in any way player benefits or player rights to negotiate that rule with the players. Also in baseball, there is a grievance procedure which has been agreed to with the Players Association one that's unparalleled by any other sport, which places all grievances about club and player matters, except those involving integrity, which are reserved for the commissioner. But the garden variety grievances goes before an arbitrator external to the game, a man now named Lewis Gill, former president of the American Academy of Arbitrators, jointly selected by the union and by the clubs. He has handled dozens of grievances in baseball, makes final and unappealable decisions with respect to them. And finally, with respect to the differences in the character of the game, games themselves, football for example, and baseball, football is able to reach out and plug from the college campus players who are ready to play professional football, already nationally known and skilled. Baseball has no such alternative. Baseball has an elaborate minor league system in which it develops its own players, into which it devotes approximately 25% of the major league gross revenues, something over $1 million per year per club, poured into the minor leagues to keep the flow of players and to keep this player development flow operating. There isn't any sport, any professional sport, that has anything that even approximates that sort of an arrangement, or those sort of expenses and difficulties of player development. For all these reasons, we believe, and the Players Association recognizes, that they're bargaining with us, that the experience in other sports is, while not dissimilar from baseball really, nevertheless, neither is it a good guide for the baseball world. There are important differences in the businesses, and we feel, as I've said, the Players Union feels that too, that we must work out our own relationships in the light of the realities of the baseball business, not in the light of what some other sport may do, or some other error principles, but on the practical level, at the bargaining table, by the people who must live with the results of their labors, the players and the club owners.
Why they came to this lawsuit? I'm using your word. You said...
You're expressing a fact, Your Honor. Your Honor, bargaining has just begun in the core of the reserve system, and like any labor union, they think they see an easy way to achieve a position of predominance, a better position. More clogged at the bargaining table, they seize the opportunity. I think there's little doubt, but what the owner's position here would be is something of a shambles. If this court would rule that the reserve system is per se illegal. As a matter of fact, I don't know how bargaining could proceed at all. I don't know what we would do at the bargaining table, because presumably not only the present system, but every modification there too. Everything that we've been working out on this area of the union would be forbidden by the antitrust laws. And even if only our present system, not speaking of other systems, were to be declared illegal, still there would be a third party at the bargaining table, and that would be the court. And the players' union, I think, would be able to use that extremely effectively. We would have been buying a new reserve system every time we bargained, and that the option would be that we would be faced with more litigation and wrath of certainty, that probability that the arrangements would be illegal without their acquiescence. I think this kind of intrusion into the collective bargaining process is not something that the courts commonly do. It's something that's quite inconsistent.
Do you think this issue here, whether the reserve clause violates the antitrust laws? I didn't know that. The issue here was whether you're exempt.
Well, Your Honor, I think the only factual issues presented here, obviously the broader issue is Toulson exemption, which we believe reaches to the entire structure of the game, not only the reserve system. But Mr. Flood and the union here are complaining only about the reserve system.
The merits of the controversy were not reached either in the district court or the Court of Appeals. They declined it. Both courts declined to reason the merits because they held that organized baseball is not subject to neither the federal or the state antitrust laws. And it's that issue that's now before the court, is it not? And if we should decide that the Court of Appeals and the district court were wrong in the view, then the normal practice be for this court to remand the case to the district court for the trial of the case on merits.
It's quite right, Your Honor, but I think there are other levels of decision here too. The labor matter that we're discussing, that I'm now arguing, that's not.
But that's just that bolsters your argument. I gather that this is not a matter for the antitrust law.
That's right, Your Honor. It's a separate, distinct reason for the use of result as well. I might also comment as in...
I believe that you could lose this issue here. That is here on the coverage and still win on the reasonableness of the reserve system under the antitrust law.
Yes, I presume we could also lose the issue here on broad coverage and prevail on the issue that no suit can appropriately be brought by a member of the collective bargaining organization in matter, which is essentially a matter of collective bargaining.
Do you think there is something unique in the union representing the great range of baseball players, all of them being neglected bargaining agent for all the players in the unit?
No, Your Honor, I don't.
But you don't report to reach the question of salary?
No, the union has expressed in its dealing, to the best that it does, not wish to bargain except to set minimums and other parameters. It is suggested that we would like to bargain perhaps not only by minimum at flow, but perhaps minimums that relate to some various seniority levels as well, but it does not wish to intrude into individual negotiations in the contract.
The unions usually do.
That's right, Your Honor, but the range of...
And why it doesn't adhere?
It certainly could, Your Honor. That would be a mandatory subject if the union were to raise it, but put that issue on the bargaining table. We would have no choice but to deal with it.
And the same with you? You put it on the bargaining table?
We would have put it on the bargaining table as well. I think both sides today have felt that it is not in the interest of the individual players or off the process too.
That's just because players are too different one from another for one union to represent.
I think that is part of your answer, Your Honor. Yes, it's part of the answer.
What's the rest of the answer?
Well, I think that the rest of the answer is that now we know the players are different, but their relationships with their clubs are maybe different as well.
You're saying the same thing.
It's a feature of the same thing, an aspect of the same. There's a wide range, obviously, of talent, of desire, and that's expressed more appropriately realized in individual bargaining.
And while the union feels that if in a new field apparently, that you and the union really shouldn't set salaries, which is usually the subject of collective bargaining, you should be able to agree on a reserve system that applies to the same to everybody.
Well, Your Honor.
Even though the players are different one from another, and the relationships are collaborative,
We don't think it will be practical to have a different reserve system for each individual player, such as you can't differentiate salaries. But that does not mean that a reserve system must necessarily monolithically apply to all players. There could be a small number of variations in the reserve system, again, depending upon seniority or some other factor. Those kinds of suggestions have been made, and they certainly will continue to be on the table. But an individual reserve system for each player, having not negotiated out separately, is a little difficult to understand. I just don't think that would not be workable. That's not to say that individual players and clubs cannot negotiate such things as long-term contracts and so on, which go a long way towards modifying the reserve system. That can be done and has been, done, and that any player is free to do this with his club. There are certainly precedents for that one. Your Honor, I'd like to briefly refer you to Jewel T. and Pennington decisions, which Mr. Justice Goldberg referred to.
let's assume that for the moment that both players and management, as they do say, pay out a collective bargaining issue. That's going to be left to individual bargaining. And then the owners among themselves agree on a range on some maximums. We will not pay anybody, no matter who it is, more than $100,000 a year.
But we certainly would not do that, Your Honor.
Let's just assume you did. Let's assume you did. Because that's one of the suggested alternatives, of course, to a reserve system. There's going to have to be some maximums.
Not one that we have suggested, Your Honor. That would be something that we would have to, I believe, state a maximum, like stating a minimum. There's something that we have to take. There is something that we have taken up with the Players Association and bargain. If the association were to say, no, we don't care to bargain.
Well, I take it then you wouldn't do that because you think that would be improper.
I think it would be improper, Your Honor.
Such as violating the antitrust laws?
No, not at all, Your Honor. Improper in terms of the labor laws.
All right, let's pursue that. I just want to get your position clear. If the owners agree on a max $100,000 a year against the background where both labor and management had put it aside as a bargaining issue that you say that it would not violate the antitrust laws, if they among the owners as to what they would pay their players.
If this were put aside as a bargaining issue, you can't make something that is not a bargaining issue, which you can agree not to bargain about it.
Let's assume, put it the way you want it. You had agreed not to bargain about it.
We had agreed not to bargain about it, and the union thereby would have acquiesced in our setting such maximums, and I believe we will be permitted to do so.
Only because of the labor exemption.
Because of the labor exemption, because of the union acquiescence, but the union could challenge that, put it on the bargaining table, and at any time dispute it.
Because of the labor exemption, because of the basic exemption to baseball antitrust laws, of course, right?
That goes without saying. I'd like to call the court's attention, if I may briefly, to a matter not mentioned in our brief, simply because it has not been published by that time. It is a Yale Law Journal article by Professor Wiener and Mr. Jacobs titled Antitrust Principles and Collective Bargaining by Athletes in 81, Yale Law Journal number 1, which agrees completely, I believe, with the analysis which were advanced in our brief, and suggests that the antitrust issues are perhaps even irrelevant here, the labor policy and its supervening.
You are suggesting that this judgment below would be upheld on the grounds not reached below?
Your Honor, I'm suggesting that the judgment number 1, that the judgment below be upheld on the grounds reached below. But alternatively, that there is an additional powerful and we think quite correct ground, which the courts below felt that not necessary to reach to a labor policy, which offers an alternative reason for.
Do you think the record is adequate for that ground?
I think the record is quite adequate.
You would oppose the remand? I presumably disagree with you on the assumption of the initial issue on which it was decided below. Would you prefer that it would be remanded, the labor exemption issue to be dealt with by the courts below per se?
Your Honor, I think it would not be inappropriate to remand that for such findings as you might feel that would be appropriate or not inconsistent with your opinion. I do believe the record has been fully developed on that point, however. I would mention only briefly that the law which Congress has decided is one which I'm sure you're aware of, and I will elaborate the point. Congress has accepted the invitation of this court, repeatedly given, as examined the baseball system repeatedly. Many bills have been introduced, many hearings have been held. The conclusions of those committee reports universally within the effect that the baseball's reserve system was something that was of the substance of the game, and it was needed to be preserved. Whenever Congress has acted, it has extended an antitrust exemption. It has never in any way limited one in professional sports. The matter is now under active consideration by Congress, which has flexible legislative power. It's not limited to applying only the garden variety antitrust laws. It can root out evils as it sees them with its flexible legislative power and deal with them quite precisely. And if there's any regulatory policy governmental of baseball that should be adopted, and Congress, as this court has repeatedly observed, is the proper body for adopting that. I would like to mention as well that the talk of stare decisis, as this court has said, the last word on stare decisis in the Tucson and Radovich opinions. Again, I need not report what this court has said, except the note that the baseball community has continued to operate under those rules, grown and invested more, and that others' reliance interests recognized in the 50s or have multiplied or even greater weight now.
Thank you, gentlemen. The case is submitted.
Then we would conclude. June 19th, 1972, the court ruled against Flood in a 5-3 decision. The majority opinion, written by Justice Harry Blackmun, affirmed Federal Baseball Club and Toulson, reasoning that baseball was exempt from trust law and that changes to this must be undertaken by Congress.
And on June 18, 1972, by a vote of 5-3, the United States Supreme Court ruled against him. Baseball was still exempt from antitrust laws, and the reserve clause still stood.
I am particularly pleased that the court has recognized the need for a reserve system and has further recognized that baseball has not disregarded the extremely important position the player occupies. Over the long history of baseball, the reserve system has constantly evolved to improve the position of the player. I am confident that this process will continue.
We lost because my guys, my colleagues, didn't stand up with me. And I can't make any excuse for them. Had we shown any amount of solidarity, if the superstars had stood up and said, "We're with Curt Flood," if the superstars had walked into the courtroom in New York and made their presence known, I think that the owners would have gotten the message very clearly and given me a chance to win that.
Curt Flood never played Major League Baseball again.
Do you guys ever have any reason to talk about that?
Well, yes. So I think it would have been Justice Blackmun's, it might have been his 80th birthday, but it was one of his big birthdays. We were having a clerks reunion, and as you know, in Flood against Kuhn, which is the baseball antitrust case, there's this kind of passage at the beginning of it that's a list of famous baseball players, and it goes on and on. And apparently he started out with about 10 of them. Then various people around the building would suggest people, and then somebody said, well, but if you're going to include, if you're going to include Tinkers, you have to include Evers. Oh, if you're going to include Evers, you have to include Chance. And so that list kind of expanded and expanded. And there was a story in the Brethren that right after the opinion came down, somebody said to him, how could you not include Jimmy Fox? And he said, Jimmy Fox was on the list. And the person said, no, he's not. And the justice went back and looked at the list, and sure enough, Jimmy Fox is not on the list. And the line in the Brethren is something like, and Justice Blackmun said, I'll never forgive myself. So for his 80th birthday, I think it was his 80th, we decided we were going to get him one of Jimmy Fox's bats. And we looked into it, and we could not find one. But it turns out that Hillrich and Bradley, I think that's what the Louisville Slugger Company's name is, they keep the measurements of every player on file for their bats. And so we went to them, and we had them replicate one of Jimmy Fox's bats, and we had it mounted on a plaque, and on the bottom it just said, I will never forgive myself, H-A-B. And we gave it to him, the clerks all gave it to him for his birthday, and I saw it actually posted in his chambers the day he died. After his funeral, we all went back to the chambers to hang out, and there was the bat, which I think was, several people asked for it, but I think it was given to the Library of Congress. And the other thing about baseball is he had been a friend of the Griffiths, who owned then the Minneapolis Millers, later the Twins, and so we would talk about baseball a lot at breakfast, and one day in the afternoon, I was in the upstairs chambers, and I got a phone call, you should come down. The justice has somebody he wants you to meet. And this group called the Emil Verbin Society was having its reunion in Washington. I guess it's a Cubs thing. And so there were these 3 guys in like bad-fitting sports coats in his office, and he introduced them to me, and 2 of them I don't remember the names because I'm not a Cubs fan at all, but the last one was Andy Pafko, who had been a Dodger as well. And so I had a nice conversation one afternoon with Andy Pafko. And the last baseball thing I'll tell you is when Justice Blackmun retired from the Supreme Court, I was asked to do one of the tributes for him in the Harvard Law Review. And one of the things I talked about in the tribute was this article that had been written called Your Law Baseball Quiz. I think I told you about this last night, where they compare different justices to different famous baseball players. And I said that, and so I tell the story of, Jackie Jensen is like Byron White because they were both better at football. And then I say, the guy who did this compared Felix Frankfurter to, among other things, Wayne Terwilliger. And in the article I just had a footnote, I said, who is Wayne Terwilliger? And so, and then ultimately I said that if I had to pick somebody for Justice Blackmun to be like, I had thought originally about Bobby Brown, because Justice Blackmun wanted to be a doctor, just like Bobby Brown became a doctor, and that I thought of, a couple of other people like that, Charlie Gehringer, because he was a little tiny, little tiny second baseman, and, a great fielder, but not a big batter. And ultimately I came out with Dave Winfield, which people might not have guessed, because both of them came from St. Paul and made something of themselves. Both of them played the game long after many of their contemporaries had retired, and both of them owed their start to a convicted but later pardoned Watergate felon. To a later pardoned Watergate felon, because Blackmun got his seat on the Supreme Court from Nixon, and George Steinbrenner is the person who gave Dave Winfield his biggest contract. And so when I read this, and I went, and the next time I visited the justice said, "Oh, I really liked your tribute a lot, but come with me." And he led me down the hall into the storeroom. He was then down at the Thurgood Marshall Center, and he pulled out a copy of the Baseball Encyclopedia, and he said, "This is Wayne Terwilliger." and took me to the page for Wayne Tool.
Twig. He was known as.
I'd never heard of him, and I'm a baseball fan, and I'd never heard of him.
Should baseball retain its antitrust exemption?
Well, I'm a big Bill James fan, and Bill James has a discussion of this where he says that if you got rid of the antitrust exemption, what you might start to see is a kind of proliferation of a third or fourth major league almost coming out of minor league teams. I'm not sure what function the antitrust exemption really performs today, given that there's now an agreement between the Players Association and the teams, right? And a huge percentage, ever since free agency, a huge percentage of the revenue has moved over to the players. I'm not sure that the existing players would favor getting rid of the antitrust exemption.
Such an anachronism.
Yeah, but hard to see that it's actually having much effect on the game itself. And the real question is how you maintain competitive balance, right? Mm-hmm. If you want to maintain the sport, the real question is how to maintain competitive balance. And without the antitrust exemption, it might be harder.